Hey everybody, welcome back to the Court of Random Opinion. My name is Neidigh. Last night we went over the Stephanie Jones motions to dismiss the amended counterclaims by Jennifer Abel, and then the one to dismiss the Wayfarer and Justin Baldoni counterclaims. Since that stream went a little bit long, I'm just here to give you some of the highlight points. And by that, I mean, why don't I just show you where the mess is? As always, Stephanie Jones is starting out with a little bit of snark against Jennifer Abel, saying Jennifer Abel's counterclaims are a rotating game of whack-a-mole. Where the minute one baseless theory is debunked, another even more implausible theory pops up in its place. In her amended counterclaims, Abel abandoned 6 of the misguided counterclaims she originally filed against Jones and Jones Works, including the fantastical story that she was falsely imprisoned by her former employer during her termination meeting. Instead, she now claims even more desperately that she was hacked by Jones Works acting as a spy. This new theory follows the familiar pattern and has an obvious purpose: to draw attention away from the text messages that she cannot and does not deny she wrote, that form the basis of Jones' well-founded claims against her, for which she has no viable defense. Now, obviously, these amended counterclaims were the first time that we saw in court documents mention that whole Van Zandt lawsuit, Sham subpoena situation. In those counterclaims, they had written that Jones was still accessing Abel's messages up until a few months ago. I want to mention about these text messages, they're the same ones we keep seeing, and while a couple of these do pertain to Stephanie Jones, a lot of it is just her gossiping about other people in unrelated contexts that are pretty much just there to kind of mess with her and cause friction between the other parties. It's not a great look, in my opinion, but there's no real stopping anyone with money and a grudge from screwing over their own public image, I guess. And here's what I'm talking about. Indeed, her two-faced and scornful behavior was not just reserved for Jones Works. Despite publicly hitching her wagon to Baldoni behind his back, she was trashing him too. Even her co-conspirator, Nathan, could not escape Abel's treachery. Alright, so she was gossiping and she was frustrated, obviously, but that has nothing to do with the claims between Stephanie Jones and Jennifer Abel. Why are we putting this out there as if we're in the 6th grade? It's like somebody found a note that I put in someone else's locker talking about someone else, and now it's being posted in federal court. That doesn't make me feel sympathetic to Stephanie Jones. It makes me feel like she's a whack job. Abel's amended counterclaims are only the latest episode in this unbroken chain of fantasy in her quest to rewrite history. So we're still arguing here about the expectation of privacy. Of course, they say Abel herself admits that the phone itself belonged to Jones Works. She returned it voluntarily, and she provided Jones Works with the passcode to access it. Her effort to convert the entirely routine practice of her employer recovering the phone it had provided to her during her employment into a smorgasbord of hacking claims fails. I don't think the two are actually directly related. The accusation is that she was still accessing things via her iCloud account until recently. So a lot of this, like I said, is going to be arguing about reasonable expectation of privacy. She elected to use her personal phone number, which she had had since high school, and attach it to the work device that was being provided to her. So there's going to be a lot of back and forth about that. I can't say how that's going to play out in court. I don't even know which state's laws are going to be applied here. But from a layperson's standpoint, if I'm looking at this, I'm thinking it feels creepy for someone to access all that information and then just willingly turn it over, especially when someone from the other side was so stupid as to immediately call Melissa and Nathan and say, "I've seen your messages. I'm going to sue you guys." At some point, some people are probably going to have this seed in their minds that this feels terrible because they're thinking back to every horrible thing they've ever said about their boss or family or even a friend when they were frustrated and didn't really mean what they were saying, and then having that instance of them blowing off steam taken out of context and then blasted to the entire country. So it doesn't seem very cut and dry just from a human perspective. I can't interpret these specific laws for you, but I can tell you how I feel like it's going to look to the public and to prospective clients. The fact that all this got out there and she didn't even try to fight it when presented with a subpoena for or by some random shell company who had nothing to do with Jennifer Abel. She didn't even notify Jennifer Abel. Here, Stephanie Jones is butthurt because they removed the part of the counterclaims when they amended the part where she was saying she still thought highly of Stephanie Jones when she was quitting the job. It seems obvious that there was a lot of placation going on here. This is a very polite message and definitely makes sense in the context of Stephanie Jones' reported volatile behavior around that time. Of course you want to make peace. Of course you want to make the transition smooth. Nobody wants to go in front of their boss who's acting like an emotionally unstable asshole and give them the finger when they still have to work there for a little while. Well, want, maybe, but nobody's going to do that. Of course, Stephanie Jones here is talking about how Jennifer Abel allegedly took some of their files and was putting them on her personal laptop before leaving the company. They say she falsely signed a statement that she had not retained any JonesWorks documents despite plain forensic evidence proving that she had been emailing documents to herself weeks before her termination. To the best of my recollection, Jen Abel has denied that and said they found nothing on the laptop. At this point, it really is just a she said situation. And when it comes to the publicist lawsuit, I'm a little bit on the fence about some of these things. I'm no fan of Stephanie Jones, but that doesn't mean that her employee didn't do anything wrong on the way out the door, you know? Not saying that she did either, just saying I don't really know. Text messages downloaded to Abel's company phone revealed that Abel had been spearheading a campaign to retaliate against Lively for allegations of sexual harassment against Baldoni, and also instigated a campaign of destruction and disparagement against Jones herself. That to me is a very heavily skewed interpretation. I don't see any evidence of that at all, but hey, like I said, if somebody's got money and a grudge. Abel identifies no personal information whatsoever that was allegedly revealed in violation of any conceivable privacy rights. Instead, she complains that text messages revealed her misconduct in participating in an unlawful retaliation campaign during her employment, but behind the back of her employer. Again, that's a heavily skewed interpretation of what happened there. Here they're talking about the hacking claims. Undeterred by the plain purposes of these statutes, Abel brings a multitude of vague, contradictory, and inapplicable claims, seeking to apply hacking statutes to the unremarkable reality of an employer recovering work text from a work phone. It's pretty clear that they were talking about the things they were accessing long after the employment was terminated. And I tend to think that somebody's going to be able to prove that, considering they put it in their court documents. Abel's complaint's core grievances include her allegation that JonesWorks provided information to third parties concerning Abel's unlawful actions on behalf of Baldoni, including allegedly to the targets of those unlawful actions. That's presuming that any of those actions were unlawful and not just delusionally misinterpreted by the lady who brought a tarot card reader to tell her employee who was struggling with fertility that she was going to get pregnant with twins. I don't care if you're into tarot card reading, it's not my thing, but if it's yours, that's awesome. But maybe don't bring it to work. That could make some people pretty uncomfortable because not everybody is okay with that kind of stuff. Abel's distress, if any, arises from being caught red-handed and does not give rise to tort claims. All right, we'll move on to the motion to dismiss the counterclaims by Justin Baldoni and Wayfair. Wayfair's amended counterclaims are, like their predecessors, devoid of any footing in law or reality and serve only as a transparent vehicle to vent Wayfair's anger over the lawful exposure of its co-founders Justin Baldoni's sexual harassment of co-star Blake Lively and his and Wayfair's retaliatory, vindictive smear campaign that followed. Your refusal to construct a sentence that doesn't feel like it runs on forever does not make this argument more convincing. Wayfair's breach of contract counterclaim primarily rests on specious allegations that Jones and JonesWorks improperly divulged confidential information. This fails on numerous fronts. First, confidential information, as defined in the agreement, excludes information which is or later becomes publicly available through no wrongful act of company. That is precisely what happened here. Information was produced and made public pursuant to a lawful subpoena, which after months of cries of phantom subpoenas, even Wayfarer finally accepts. Dude, did I miss something? Nobody is rolling over and accepting that. This is very heavily disputed. The sequence of events that led up to them getting that subpoena, which was not signed off on by a judge and no one was notified about, are really fucking sketchy at best. Wayfair's false allegations are hopelessly vague, failing to identify any purported confidential information with any specificity. Are you okay? Of course, they're also trying to cite the Federal Speak Out Act, again, which precludes enforcement of pre-dispute non-disclosure clauses in matters involving sexual harassment and retaliation, and accordingly renders the confidentiality clause, the Wayfair agreement, unenforceable. And that's where you lose a lot of people, because no matter how this plays out based on specific legal procedures, even if you get this dismissed, a lot of women are going to see this entire situation as very sketchy and view it as an exploitation of a law that's meant to protect people who have actually been sexually harassed, abused, assaulted, etc. So it took about 2 paragraphs to fuck that one up. Wayfair's amended counterclaims are not just meritless, they are retaliatory. They are yet another effort at a smokescreen transparently leveraged to shift the limelight from Wayfair and its founders' bad acts. Wayfarer breached its contract with Jones Works and participated in a campaign to take down Jones and the business she spent years building. Wayfarer must be held to account absent the distraction of faulty amended counterclaims. Its continuing gambit should not be countenanced, and the court should dismiss the amended counterclaims with prejudice. And they're saying it's so baseless that it warrants an award of attorney's fees under New York's anti-SLAPP statute. All right, that's all I got for you right now. Like I said, I'll post a link to the full documents in the comments below, and I'll see you all soon.